Judgment. For judgment, item number 1, JCRL 65 of 2006.
The appeal is dismissed. The bail bonds are cancelled. The appellant should surrender by 16th.
JCRL 93 of 2006.
The appeal is dismissed. The accused should surrender by 16th of August.
CRL 13 of 2012.
The appeal is dismissed.
WPC 4472 of 2012.
We've disposed it of increasing the compensation to 2 lakhs.
WPC 7209 of 2013.
The impugned award is set aside. Writ petition is allowed, but no costs.
Item 6, STRB 8 of 2013.
We've answered it in favor of the SSC. Sorry, we've answered it in favor of the SSC. Greatly obliged, ma'am.
Obliged.
The petition is disposed.
Item 7, WPC 8610 of 2015.
Writ petition is dismissed.
Item 8, WPC 22924 of 2020.
Writ petition stands dismissed.
Appeal on 27 July.
Yeah. Written submissions.
I am submitting it.
All right.
Not of submission.
All right.
For admission, item number 9, WPC 3050 of 2014.
So item 9, I am appearing for opposite partner 4, that is Bhubaneswar Municipal Corporation.
All right.
Copy notes of the admiral.
Of what?
Counter copy, madam.
Sorry?
Counter copy,
No,
madam.
tell us what the matter is.
Madam, this is a matter for violation of lease condition by the allotee being used the residential plot in with building standing there as commercial building against BDA and municipal corporation.
No. To which persons?
Madam,
Sir, who are the persons against whom you are making a complaint?
paragraph 6.
I don't know. I don't think you've understood the question. I'll ask my colleague to ask you the persons against whom the persons against whom the complaint has been made. They have not been made parties in the writ petition.
No. Madam, here BDA planning authority and municipality also granted lease. So municipality and BDA are party.
Have you understood the question?
3 and 4.
Have you understood the question?
Madam,
But the persons in whose favor the leases have been granted and they have violated, they're not the parties in the writ petition. Who are they?
these the my lord, opposite my lord. My lord, liberty may granted.
All right, counsel the petitioner seek leave to withdraw this petition. with liberty to make a representation to the authorities naming the persons who have allegedly violated the BMC regulations. And after following up on such a representation, and if any cause of action survives, to seek appropriate remedies in accordance with law. This post of is withdrawn with liberty straight.
Obligement.
Supplemental list for a press admission ARBP 38 of 2022.
All right, notice returnable.
I have instruction to
Nine
adhere in this case, my lord.
You are accepting notice. Are you opposing the appointment?
No, my lord, it will be settled, my lord.
Yes.
It's not necessary to appoint, my lord.
Yes.
Yes.
All right. Should
Let's
I-
have the copy. I'll take instruction.
All right. Should we have it in September itself then?
Pardon,
2nd September?
Yes, ma'am.
Okay, 2nd September. He accepts notice list on 2nd September.
Supplemental list item number 2.
Pass over.
Supplemental list item number 3. ARBP 57 of 2021.
And I have already deposited the requisites, my lord. A fresh another requisites I'll file within 3 days.
So how many times? Already it was adjourned on 8th April, then again on 6th May. You're not interested, I think.
No,
You're not filing the requisites.
my lord, I have already filed and that is on acquisition. I have already filed the receipt is there.
When?
21/4/22.
No, sir. Fresh notice was issued on 6th May.
Yes, at that time my leg was fractured.
No, what is that to do? Some clerk has to file. You are yourself not going and filing. You're giving it to your clerk.
Within the course of the day, I will file.
So this
Today.
is the last opportunity.
Yes, ma'am.
Because there is a mandate of the Supreme Court that all these 11(6) applications have to be disposed of within 3 months.
My lord. Today in course of the day, I will deposit the fresh requisition.
Counsel for the petitioner seeks a last opportunity to serve the respondent. Accordingly, a last opportunity is granted to. As a last opportunity, fresh notice be issued to the respondent returnable. 16th September.
Supplemental list item number 4.
Item number
All right.
Your lordship, item number 4 and 5 on behalf of Mr. Panda. It will be deposited next week.
Why next week, sir? Some 494, you should do it today. 500 rupees, why next week? Depositing 500 rupees, why next week? You should do it today.
Okay, lordship.
Counsel the petitioner assures the court that in both these matters, 4 and 5, that the deficit court fee will be deposited today.
Your lordship, may pardon me. Let it be. Your lordship may order it for Monday.
Sir, 500 rupees.
No, I'm
Given
not
the
a contracting
petition, you
party.
want time for this.
Lordship,
Please.
pardon me.
Sorry, refused. Have some reasonable request, sir. 500 rupees you can't pay today. What is all this? This time was given in 13th May. Why should, maybe we should just dismiss it? What do you say? Let us dismiss it.
Your lordship,
15th July. Despite 2 opportunities granted on 13th May and 15th July 2022, defects have still not been removed. Even today, counsel the petitioner seeks more time. Full stop. If the deficit court fee is not paid during the course of today, the petition will stand dismissed without any reference to this court.
4, 5, and 6.
4, 5, and 6.
Supplementary list item number 7.
List after defects are removed.
Supplementary list item number 8.
Please, my lords, deficit court fees, I'll file it today, my lords.
Has been filed today.
My lords, in fact, it would have been filed actually, my lords. I have taken steps to file it, my lords, that 498 rupees.
Counsel, the petitioner states the deficit court fee is being filed today. Notice returnable 16 September.
Supplementary list for admission item number 9.
There is already arbitrator appointed and he has participated, petitioner participated in the arbitration proceeding. Page 19. He admitted in his petition.
Who's for the petitioner? We pass it over. Let the petitioner come.
Supplementary list item number 10.
Item
There's
10,
an
I'm
item number
filing
10,
the
because I
rejoinder
appear for
today.
the respondents, my lord.
I'm for the petitioner. I'm filing the rejoinder today.
It's all right. What's the matter about? Let's decide this.
Here, what has happened is there was for one project, 3 agreements were entered into between the parties. There was one letter of acceptance issued by the respondent. Then 2 work orders for additional work were also issued. In the first letter of acceptance, admittedly, there was no arbitration clause. In the subsequent 2 work orders, there was an arbitration clause. I invoked the arbitration clause. Your Lordship may see page 84, referring to all 3 agreements, to which they have agreed also. Only the name could not be finalized. Now they are saying that because there is no arbitration clause in one of the agreements, the petition should not be allowed. But they have agreed already to that. To the reference, Lordship may see page 84.
Yes.
Page 84, reference. LOA number, work order, both work orders.
No,
Then-
this is your letter.
This is my letter.
Huh.
Then they have agreed to that on page 85. In the letter, I have referred to all the 3 agreements that I am for all disputes of all 3 agreements. I am invoking the arbitration clause. But at page 85 also they agreed. Now in the counter, they're saying that in one of the agreements, there is no arbitration clause. So the petition should not be allowed. But my humble submission is that since they have already agreed and it will be a bifurcation of the, because it was for the same project, there were 3 separate agreements entered into. And there are no other parties also.
Yes, Mr. Sinha.
My lords, may I submit this, my lords? The agreements are not so intertwined, my lord, that it cannot be segregated, my lord. So my humble submission is only this, my lords. As regards the 2 arbitration, as regards the 2 LOAs or the agreements, my lord, which has an arbitration clause, my lord, we have no dispute, my lord. My lords can appoint.
Mr. Sinha,
anybody
what's
as-
the point? Filing a suit for one thing and arbitration for the other 2. How is it your advantage? It
Because-
makes no sense. Same parties, you want to have suit in for one dispute and arbitration for 2.
Because
Makes no
my
sense.
humble submission would be this, my lord. There is a section 9 petition which is pending adjudication there, my lord. Here
That is
they are
different.
asking. Sorry, my lord.
No, 9 is, of course, in anticipation of the arbitration, correct?
Absolutely, my lord. Absolutely.
Ah.
So, my lord, my only limited submission is this, my lord. That, my lord, my learned friends can withdraw this, file a fresh application for the 2 agreements,
No,
my lord.
why are you insistent that there should be a suit for the other one? I don't understand. It's between the 2 of you. You might as well have all the disputes settled in arbitration.
And they had agreed also. Lordship may see page 85. Only the
No, my
name.
lord, that agreement, that anyway cannot be said that I've agreed to the fact that I cannot have a right to oppose the fact, what's there in.
You should have
fact-
some logic. There must be
No, my
some.
lord, so my lord, I leave it to my laws, my lord, to decide, my lord.
All
I
right.
can only press to an extent, my lord. My laws may appoint anybody that my laws feel suitable for this.
All right. You say counsel for the opposite party states that while the opposite party is agreeable to arbitration as regards the disputes arising out of the 2 work orders dated 1st August 2020 and 17th March 2020, they have objection to the dispute arising out of the LOA dated 20th February 2018 referred to arbitration. Paragraph. Counsel for the petitioner, on the other hand, points out that when the petitioners wrote to the opposite parties on 18 February 2022, proposing the name of an arbitrator, proposing the appointment of an arbitrator, they made a reference to all three agreements, all three documents, that is the LOA and the two work orders. And the opposite parties had, by the reply dated 16 March 2022, suggested the name of an arbitrator. So the only difference was about who should be appointed as an arbitrator. Paragraph. Indeed, the court finds that no purpose would be served if between the same parties disputes arising out of the work orders are referred to arbitration, but not the dispute arising out of the LOA. Full stop. Therefore, the court is of the view that notwithstanding the LOA may not have contained an arbitration clause, considering that the disputes are between the same parties and the work orders were issued in sequence following the LOA, all the disputes can well be adjudicated by the same arbitrator, as the disputes are between the same parties. Paragraph. Accordingly, the court appoints
May I suggest Justice P.K. Mishra?
Justice P.K. Mishra.
No, my lords, can I just suggest, my lord, to appoint anybody that my lords would select? No, let it not come from either of us, my lord.
All right.
Claim is of 8.1 crore.
Justice Pramath Patnaik,
Okay.
as the
Great.
sole arbitrator to adjudicate the disputes between the parties, including the claims and counterclaims. The arbitration will take place under the aegis of the arbitration set.
All right.
Grateful, my lord.
Supplementary list passed over matter item number 2.
None appears to pass over.
Appearing, he's there.
Ah,
May I please address? My lord, the petitioner was the successful EPC contractor for agreement under Annexure 2.
so
And
the date of the agreement is 2015.
yes, my lord.
When did the cause of action arise?
My lord, the cause of action arise in the paragraph number 9, and that is 22/11/2011. The conciliation meeting was called by letter dated 10/11/2021 by the respondent.
All right, you say notice returnable, 16 September.
Passed over matter item number 9.
16th September.
Yes,
There is already a arbitrator appointed and he is participating.
I know. Where is the petitioner, sir? Despite a passover, none appears for the petitioner. Mr. Barley, appearing for the opposite party, states that an arbitrator is already appointed and the petitioner has been participating
He is Annexure 3 and he is admitted
in the arbitration proceedings.
Para 12 and 13 he is admitted. The petitioner thereafter appointed advocate to defend his right in that arbitration proceeding. The advocate of the petitioner in the said arbitration proceeding by his petition approves. So he has already participated.
In the interest of, we just adjourn it once. In the interest of
Because
justice, list on,
stay order is continuing.
where is the stay order?
Yes, status quo.
Acha, the interim order is accordingly vacated. List, in the interest of justice, list on 5th August, next
But
week.
there is a stay order is there.
Vacated, sir.
And there is already arbitrator or appointed what nothing. remains.
Vacated.
Malad?
The stay order is vacated now.
No, but why should proceeding should pending? Because there is already arbitrator is there.
Not the next week.
This arbitration list is open.
Ah.
Special list. Special list for orders item number 1.
Item number 1, my lords. My lords, the conducting counsel is not well, my lords. My lords, may kindly.
Tell us what the matter is about.
My lords, actually, the file is also not available with me. It's actually,
Say, counsel, the petitioner says the file is not available. The petition is dismissed for non-prosecution. As and when the file is traced, it can be revived, interim order is vacated. The copy of the order be sent to the concerned court forthwith.
My lords, may kindly give me some time. Actually, the conducting council is. My lords, may kindly pass over. Otherwise, I'll try to.
All
get
right,
the
pass
file.
over. All right, pass over.
Specialist item number 2.
None appears. This is a non-prosecution. The interim order is vacated.
Specialist item number 3.
None appears. This is a non-prosecution. Interim order is vacated.
Specialist item number 4.
None appears. This is a non-prosecution. Interim order is vacated.
Specialist item number 5.
Same order. Same order.
Specialist item number 6.
Item number 6, well, no instruction.
No instructions. Dismissed. Interim order vacated.
Specialist item number 7.
Sir, item number 7 available. Saurabh Bera party in person versus state of Orissa. Arbitration number 372022.
7. Item 7.
Item number 7.
My lord, 7, 8, and 40, my lord, arising out of same incident, my lord. In the meantime, my lord, there is a law relationship between petitioner number 1, my lord. Sorry, 1, my lord, with petition number 3. In the meantime, they have settled the dispute and both are leading their conjugal life happily, my lord. And I have given the marriage certificate, my lord.
Giving copies, sir.
I'll show.
Counsel, the petitioner has handed over copy of the marriage certificate evidencing the marriage between petitioner number 1 and opposite party number 3. The marriage certificate is dated 27th December 2014. He states that both parties are living happily.
My lord, my friend is appearing for the OP.
Counsel for opposite party number 3 confirms this. In that view of the matter, all these 3 petitions are allowed. And PS case number 188 of 2013 corresponding to GR case number 518 of 2013. Pending the file of the JMFC bracket O Bhubaneswar and all orders passed therein and consequential thereto, I hereby caution.
My lord, all are different PS, man.
So each one, prayer you take.
My
All
lord.
right. All right.
Oh, charged. 7, 8, and 40. Specialist item number 9.
9 may I please, I'm in virtual mode, my chief. The case has been registered under section, I'm in virtual mode, my chief. The case has been registered under section 452, 341, 323, 294, 354, 5 and 506 and 307 IPC, my lordship. The case arising of a dispute between the informant and the present petitioner. The present petitioner is the ladies committee member, my lordship. My lordship, the present petitioner has a challenge in the for quashment of the order, my lord, which is annexed in the, my lord, annexure 2, FIR has been annexed in annexure 1, my lordship.
Can urge all these pleas at the appropriate stage, sir. Permitting the petition to urge all the pleas at the appropriate stage in the trial court. The interim order is vacated. The petition is disposed of.
Right. Specialist item number 10.
10 may I please, only 506 and 34 by IPC and 3 SCST Act.
Whatever, sir, the addressee and all long absent, same order in 10 also. All right.
Specialist item number 11.
11, my lord, the matter has been settled between the parties, my lord. My lord, I have filed page 12 is the Rafanama, which says, my lord, at the intervention of
This is all handwritten, sir. Unless there's an affidavit, it won't work. This is all handwritten, sir. The opposite party is not.
This is handwritten by the
endorsement of the process server is address not found.
I will file an affidavit, my lord.
No.
My lord,
You can go for the trial court and say all this.
dispute between two neighbors.
In the last 8 years.
Dispute between two neighbors, my lord.
All right. You should serve the other side. The addressee is not found. You see, the last 8 years, the opposite party has not been, opposite party number 2 has not been served. Permitting the petitioner to raise all the pleas at the appropriate stage before the trial court, the petition is disposed of. The interim order is vacated.
Specialist item number 12.
12, 13, 14. Withdrawn. Counsel petitioner has filed a memo saying that he does not wish to press these cases. Dismisses not pressed, the interim order is vacated. All three.
Item number 15.
None appears dismissed, not prosecution.
Specialist,
Ma'am, sir, no instruction.
All right. This is 15 or 16?
15, sir.
15.
Ah,
Specialist item number 16.
none appears dismissed, not prosecution.
Specialist item number 17.
Lordship, liberty may be granted to urge for learned court below.
Permitting petitioner to raise all, please. All right.
Specialist item number 18.
None appears dismissed, not.
Specialist item number 19.
None appears dismissed, not prosecution.
Specialist item number 20.
None appears dismissed, not prosecution.
Specialist item number 21. Permitted to withdraw, my lord.
Counsel the petition seeks leave to withdraw the petition. Dismisses withdrawn, interim order is vacated.
Specialist item number 22.
None appears dismissed, non prosecution.
Specialist item number 23.
None appears dismissed, non prosecution.
Specialist item 24.
But no instruction.
No instructions, dismissed.
Specialist item 25.
May it please, Lord. I'm on VCO, Lordship, maybe Lord. Lordship, there's a similar matter of the same petitioner, CRLMC 3409 of 2015. It is pending before Honorable Justice R.K. Patnaik Court, Lordship. May be tagged along. Lordship may direct it to the
All right. List along with CRLMC
3409 of 2015.
3409 of 2016 before Justice R.K. Patnaik for 5th August. Right.
Obliged.
Specialist item number 26.
None appears dismissed, non prosecution.
Item 27.
Please, my lord.
Yes.
Ask my associate to give a memo, my lord.
Yes.
Last week only your lordship has transferred similar matters to the appropriate bench, my lord, to be listed, my lord. Has your lordship got it, my lord, that memo?
Yes, yes. Same order. Order. Same order. Order.
And 67, my lord.
Order.
Item number 27 and 67. Prosecution.
No, but when will it now be listed? Listed on 5th August.
My lord?
No, in those two orders, it says list today.
That would be listed before Justice Sahu now, my lord.
Yeah, but today itself or 5th?
Yes, yes.
No, yes, meaning what? Today or 5th?
That is not being, I am given to understand, not being taken up today.
It's not being taken up today.
That is what I was told.
All right, 5th. Keep it for 5th. All right. Same order for 5th. All right.
I'm appearing. 67, my lord.
All right.
I'm appearing for the opposite party in item 67, your lordship.
All right. All right.
Okay.
Specialist item number 28.
No instruction.
No instructions, dismissed. Interim order is vacated.
Specialist item number 29.
None appears dismissed, non prosecution.
Specialist item number 30.
Permitted to withdraw and liberty may be granted to raise all the points subsequent stage.
All right. Permitting the petitioner to raise all the points. Right.
Specialist item number 31.
None appears dismissed, non prosecution.
Specialist item 32.
None appears dismissed, non prosecution.
No, my lord, I am here, my lord. Am I audible?
Yes, yes.
I am here. And item 32, I am here.
Right.
May I please, your lordship? My lord, here is a case where this honorable granted stay and I have filed the requisite for issuance of notice.
You've not taken steps, sir. You've not taken steps.
My lord, I have taken steps, your lordship. I have got the receipt. I have got the receipt.
Anyway, sir, for the last 8 years, nobody is served, nobody's appeared.
My lord, I produce all relevant records and postal requisites. However, the noting has come that the correct address I have not filed.
So you can show all this to the trial court now. If you had served them, that I can pass orders. If you're not served, you show it to the trial court.
My lord, what happened, your lordship, in this case, while granting, my lord, the matter has been settled between the parties because for
for misutilization of the act, my lord. The informant side himself, they have fired the house, my lord, to get the benefit of my lord atrocity act. That was the compromise lordship may see.
No.
Lordship may
You
see.
say permitting the petitioner. No, sir, we can't see because nobody is appearing for the other side. All right.
All right,
No,
I'll take special messenger notice, my lord.
No,
My
not
God.
now, not after 8 years. You should have done it by now, sir.
My lord,
Permitting the
I'll
petitioner to
take
raise all the
notice by
pleas
special
at
messenger.
the appropriate
Lordship,
stage. Are you appearing in this matter? 32.
I am item number 26, Your Worship.
That's all. You wait. All right.
Well, I'll deposit the
Permitting-
cost at my cost. Let the notice be given to the my lord.
Sorry,
the-
sir, sorry. Permitting the petitioner to raise all the pleas urged in the present petition at the appropriate stage in the trial court, the petition is disposed of, interim order is vacated. Yes.
My lord, what happened, your lordship? My lord, may I submit one thing? Lordship, have a glance one moment, my lord. In this case, my lord, the victim himself filed an affidavit, and the compromise also.
You can point it out to the trial court, sir. You can ask for a discharge.
Matter can be ended because she has already been stated that these petitioners are no way connected in the alleged crime, my lord.
You point it out to the trial court. You point it out to the trial court.
Specialist item
Lordship, that
33.
is a compromise. That is annexed in Oriya language. That is the whole difficulty, lordship.
All
To
right.
visualize the things, my lord.
All right.
I can explain. I can give it in my lord, translation copy. Lordship may see that. So that is nothing. 2014. That's why stay has been granted by this honorable court.
All right.
Otherwise, I don't have any case, my lord. Unless the
Item-
litigation will come. May I give it, lordship, by type copy, your lordship?
Why are you not calling out, sir?
Item 33. Specialist item 33.
None appears to assist non-prosecution. Interim order is vacated.
Specialist for admission item 34.
None appears to assist non-prosecution. Interim order is vacated.
Specialist item 35.
None appears to assist non-prosecution. Interim order is vacated.
Specialist item 36.
Lord, 36, there's no instruction as
No instructions to assist non-prosecution. Interim order is vacated.
Specialist item 37.
None appears to assist non-prosecution. Interim order is vacated.
Specialist item 38.
The memo is taken on record. Dismisses withdrawn. Interim order is vacated.
Specialist item 39.
May I plead your lordship? Your lordship, challenge the order of cognizance passed by the learned court below pursuant to a complaint case filed, which was referred under section 156(3) CRPC to the police station, your lordship. The relevant part, which I.
So you not served the other side. Have you served?
Yes, your lordship. I have the receipt, your lordship. Since 1st August 2014, I already served an extra copy to the state as per direction, your lordship.
What's the offense under?
Private opposite party. Private opposite party.
What is the offense, sir?
Offense, your lordship, 341, 323, 452, 294, 506, 354 A and B, your lordship. Only what I draw.
There's no affidavit of the victim, sir.
Lordship, only your lordship may peruse page 19, your lordship, of my brief. That is the final form that given by the police after conclusion of the investigation. During examination, the lady denied for medical examination, chance examination, conducted raid of the house.
Sir, unless there is a compromise, she has filed a protest petition, correct?
No, your lordship. She filed a complaint case which was referred under section 156(3), your lordship.
After final form, she must have filed a protest or.
No, your lordship.
How about the magistrate nevertheless took cognizance?
Magistrate took the.
That is why you're here. You're here before this court only because of that.
Magistrate took cognizance, your lordship.
Ah.
No witness were examined, your lordship. As per the investigating agency, your lordship. No witness.
Sir, unless there is a compromise, if you're able to file the affidavit of the victim, one can consider, not otherwise. You say permitting the petitioner to raise all the pleas urged in the present petition at the appropriate stage before the trial court, the petition is disposed of.
I may have the liberty to raise all the questions.
That's all that is over, sir. Just dictated it.
Specialist
Interim
item
order
number
vacated.
41.
None appears to assist non-prosecution. Interim order vacated.
Specialist item 42.
None appears to assist non-prosecution. Interim order vacated.
Specialist item 43.
None appears to assist non-prosecution. Interim order vacated.
Specialist item 44. I am for the opposite party, my lord. Mother has lodged the FIR alleging that the petitioner kidnapped her minor daughter. I am for the opposite party.
None appears. This is not prosecution. Interim order is vacated.
Specialist item 45.
45 matter has been settled. My friend is appearing.
All right.
Has given
Both parties, counsel for both petitioner as well as opposite party number 2 state that the matter has been settled. In that case, the matter.
Is filing a affidavit just now.
The joint affidavit is taken on record. All right.
Affidavit by
opposite party number two.
Okay, the affidavit of opposite party number 2 is taken on record.
The party is present in the court, is swearing his affidavit where the
Just
board.
pass over one pass over.
Both commissioners.
All right, pass.
Specialist item number 46.
None appears. This is not prosecution.
Specialist item 47.
None appears. This is not prosecution.
Item 48.
48 my lordship, no instruction, my lordship.
No instructions dismissed.
Item number 49.
49 my lordship, also no instruction, my lordship.
Same. All right.
Specialist item 50.
None appears. Dismissed. No prosecution. Interim order is vacated.
My lord, 46.
Yes.
My lord, I 46.
Yes. Yes.
46.
My lord, 46 take instruction. It is a old matter, my lord.
No, no. Either you have instructions or you don't. You don't have instructions. Permitting the petitioner to raise all pleas raised in the present petition, the appropriate stage the trial court petition is disposed of.
Specialist item number 50.
None appears. Dismissed. No prosecution.
Item 51.
May I please, your lords? 160, as per direction of this honorable court, 164 statement was recorded. That is with the government advocate as also with me. Now she stated in the 164 that both are love with each other on our own sweet will, left with the boy, my lord. This is the 164 statement.
It's the statement of the victim under section 164 CRPC indicating that she left her of her own will has been handed over in court. This is not disputed by counsel for the state. That view of the matter, take from the payer clause, FIR number so and so, corresponding to GR number so and so, pending the court of the JMFC Sorada is hereby quashed.
Obliged.
Specialist item 52.
None appears. This is not prosecution. Interim order is vacated.
Item 53.
Same.
Specialist item 54.
54 also same, my lord. 164 statement was recorded. That is with the
Same order as
51.
51. All right.
Specialist item 55.
55, my lord. No instruction.
No instructions dismissed. No prosecution.
Specialist item number 56.
Wait, please, my lord. I'm appearing on behalf of Mr. Debashish Panna, my lords.
Yes.
I pray the matter may be taken up some other day, my lords.
No, 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 no. You either tell us what the matter is about. Yes. Or we pass it over.
I pray for Passover.
All right, pass over.
Okay.
Item 57.
None appears.
57 may be used. I mean, virtual mode. The case has been registered under section 419 and 420 and 34 IPC, my lordship. The present petition is challenge for quashment of the criminal proceeding, my lordship. Allegation against the present petition is the informer has taken away the 1,20,000 rupees, my lordship. That is the 420 allegation, my lordship.
Anyway, so you can raise all these at the problem. Permitting the petitioner to raise all the pleas at the appropriate stage. The petition is disposed of. The interim order is vacated. Yeah.
Specialist item 58.
None appears. This is not possible.
Item number 59.
59, Lordship. I am on BC. Kindly permit me, Lordship.
Yes.
Here, Lordship, the order of discharge is under challenge, Lordship. And as I found, there is no stay order operating. So I pray, Lordship, may say that I may raise all my pleas during
All
the
right.
trial. Lordship.
Permitting the petitioner to raise all the pleas at the appropriate stage. So for the trial court, the petition is disposed of. The interim order is vacated.
Specialist item number 60. Item 60.
None appears. This is not possible. Interim order is vacated.
Item 61.
None appears. This is not possible. Interim order is vacated.
62.
May I please, Lordship? Lordship, kindly permit me to raise all the pleas before the appropriate
All right.
authority.
All right. Permitting the petitioner to raise all the pleas at the appropriate stage.
Obliged, Lord.
Specialist item 63,
No instructions, dismissal not possible.
specialist item 64,
64, my lord, here I have challenged the order of cognizance as well as the pendency of the criminal proceeding, my lord. So case under section 498, A 506/34 and 406, my lord. So the proceeding, the same order was passed by challenge by the husband, and this honorable court was pleased to pass it on the ground of compromise petition filed between the husband and wife.
Arising out of the same proceedings, the husband had filed criminal MC 1732 of 2013, which was disposed of with this court by the order dated 7th August 2014, recording a compromise between the parties. Accordingly, the present petition is also disposed of in the same terms.
specialist item 65,
None appears to not possible. Interim order is good.
specialist item 66,
Your Lordship, in item 66, I seek for a passover, Your Lordship.
Whom are you for?
Your Lordship, on behalf of Mr. D. Naik, Your Lordship, for the present petitioner, Your Lordship.
66 criminal MC 4828.
Yes, Your Lordship. Your Lordship, yes, Your Lordship, CRLMC 4828, Your Lordship.
All right, Passover. All right.
Item 65. 65. Item 65. Well, in this case, prayer of the petitioner was the annexure one, that is the FIR, my lord. My lord, victim is a petition number 1. Other rest of the family member is your opinion of petition number 2 to 5 is the accused person, my lord. As per flag B, 164 statement by the victim, FIR is not maintainable, my lord. Victim is a major, my lord, about 20 years age. Father has no right to lodge
Flag B. You have a flag B there?
Flag B, my lord, 164.
What did she say there? Give him a copy of that. You have it?
It's not on my.
164 copy was not with me.
Not.
In Orissa, subject copy not granted 164 statement. Honorable court are directed to file 164 statement. I will produce before the court, my lord. Petition also supported by affidavit. Victim also filed affidavit. The petition number 2 is my husband. I am a legally married wife of the petition number 2. Father has absolutely no right to file an FIR against accused persons.
Yes, my lord.
All right. The victim girl has filed an affidavit. Filed the statement of the victim girl under section 164 or CRPC has been placed before this court. She states therein that she has been married to petition number 2, my lord, and is living happily. That view to matter. PS case, Oletpur PS case 81/3 of 2009, corresponding to GR case number 1126 of 2009, pending the court of the JMFC (rural) Cuttack. And all orders consequent thereto. And proceedings are hereby quashed.
specialist item number 68,
Counsel, the petition seeks leave to withdraw. Dismissal is withdrawn. Interim order is kept.
specialist item number 69,
None appears to assist not possible.
specialist item 70,
Please the court. It's a case of postman, my lordship. It's a elopement case. During the filing of the case, the petitioner and the opposite party number 3 have already married and living happily.
All right. You see the statement of the victim under section 164 CRPC is at annexure 4. In it, she states that both the petitioner and the opposite party number 3 have married and are staying happily. That view of the matter. The proceedings in GR case number 1140 of 2012, pending the court of the SDJM Jagatsinghpur, arising out of Nagaon PS case number 111 of 2012 is hereby quashed.
specialist item 71,
None appears to assist not special. Interim order is kept.
Pardon to mention, my lord.
My lord, item 57 and 60.
You have to wait, sir.
No instruction. Item 72.
I am appearing for the informant.
You have to speak in the mic.
So then, to my lord, on behalf of Mr. P.K. Maharaj, the matter has been settled between the parties, my lord.
I see. Counsel both for the petitioner as well as the informant inform the court that their disputes have been settled. The affidavit of the informant and the injured are both placed in record. In that view, the matter. Proceedings in Ranapur PS number 207 of 2014 corresponding to GR case number 2207 of 2014 pending the court of the JNFC Ranapur and all proceedings consequent thereto are hereby quashed.
Specialist item 73.
Obliged. None appears to assist non-special. Interim order is subjected.
Item number 74.
None appears to assist non-special. Interim order is subjected.
Item 75.
See, my lord, pursuant to the criminal proceeding, offence relating to my lord 498 IPC, my lord, under section 13B, my lord, Hindu Marriage Act, the divorce already been, my lord, granted between both the parties, my lord, on the compromise basis, my lord. That is copy already, my lord, served your lordship, my lord.
All right. And copy of the order passed by the family court in civil proceeding number 160 of 2014, granting divorce to the petitioner and opposite party number 2 by dissolving the marriage under section 13 capital B of the Hindu Marriage Act 1955 has been placed in record. It also records the terms of settlement between the parties. In that view of the matter, GR case number 973 of 2012 arising out of Bhuvaneshwar Mahila PS case number 146 bracket 48 oblique 2012 pending the court of the SDGM Bhuvaneshwar and all proceedings consequent thereto are hereby quashed.
Specialist item number 76.
Beg your lordship's pardon. Item 74, I was a little bit late, my lord. In that case, I am for the petitioner, my lord. Last occasion, I submitted that the informant appeared, but no affidavit has been filed. The informant is bedridden. She is unable to come, my lord. NBW in this case was stayed, my lord. Let it be quashed. The petitioner shall face the trial. This is an offense under section 354. Major offenses.
While directing notice to issue the present petition on 9th December 2014, this court had stayed the NBW issued against the petitioner in GR case number 187 of 2006 pending the court of the JMFC bracket rural Cuttack. Counsel petitioner states that the parties, that is the petitioner and opposite party number 2, have settled their disputes. But opposite party number 2 is unable to appear due to illness.
Illness, my lord.
In the circumstances, it is directed that the NBW issued against the petitioner will stand quashed, subject to the petitioner appearing in the court of the JMFC rural Cuttack in the aforementioned case on 5th September 2022.
Highly obliged, ma'am.
The petition is disposed of.
Specialist item number 76.
In this case, my lord, the stay order was granted by this honorable court, and it was vacated on 3/10/2019 because your lordship apex court judgment 6 months it will last every stay order. It was vacated. In this case, my lord, this case was arises out of the writ petition which has been challenged by the order of the state level scrutiny committee, and your lordship has given stay in the writ petition. By that, I had asked for the criminal proceeding on the basis of the committee report has to be stayed. Your lordship has earlier stayed it. It was vacated because of the apex court. Your lordship order that it will last only 6 months.
You can raise all these pleas at the appropriate stage. Permitting the petitioner to raise all the pleas raised here at the appropriate stage, the petition is disposed of. Interim order is vacated.
Specialist item 77.
None appears. This is not possible. Interim order is vacated.
78.
None appears. This is not possible. Interim order is vacated.
Item number 79.
item 79, Lordship, the file is not with me. I just check the file. It's a order taking cognizance has been challenged, Lordship. I pray liberty may be given to the.
Right. Permitting the petitioner to raise all please raised at presentation at the appropriate stage.
Specialist item 80.
I am for the informed wife opposite party. In the matter, in the meantime, 498 case matter already compromised. I am for the opposite party wife.
Counsel appearing for opposite party number 2, wife,
My lord.
states that the matter has already been compromised. Consequently, the order dated 20th October 2014 passed by the SDJM Parliament Committee, taking cognizance in GR case number 109 of 2014 corresponding to PS case number Parliament Committee PS case number 237 of 2014 and all proceedings consequent thereto are hereby quashed. Petition is disposed of.
Password. Specialist fast or matter item number 1.
May I please?
Yes.
My lords, here, my lords, the petitioners are the employee. We are the employees of opposite party number 3, my lords, which is a share and stock broking agency, my lords. My lords, here what happened is that the opposite party number 2 approached us to invest some money in the stock market, my lords. My lords may now kindly look at Annexure 4, my lords.
So in all these years, the opposite party has not even been served.
I'm
11 years now. 11 years now. See, it's better you go back to the trial court, sir.
My lords,
Petitioner to raise all the pleas. Yeah,
my lords, direct, I'll serve the opposite.
No, not at 11, after 11 years.
For the issuance of notice, my lords.
No. Permitting the petitioner to raise all the pleas raised in the present petition at the appropriate stage in the trial court.
This is merely a civil dispute, my lords. actually.
Whatever, sir. You can always apply for discharge there. The petition is disposed of, informed is vacated. All right.
My lords.
Specialist
I'm obliged
item
to this.
26.
Yes, Mr. Mahapatra.
My lord, on behalf of HN Mahapatra, it has matter is already settlement.
All right. Counsel, the petitioner states the petition has already been settled.
I am appearing on behalf of the option number 2.
Yeah. This is
Yeah,
confirmed by opposite party number 2. In that view of the matter, the PS Tigriya PS case number 124 of 2014 corresponding to CT case number 123 of 2014 pending the court of the JMFC Tigriya and all proceedings consequent thereto hereby quashed. The petition is disposed of.
Fast or matter specialist item 45.
45, my lord, they have now served a copy of the affidavit. And you'll also indicate my name, Mr. Dhananjay Munda has joined in the state panel. Yeah, I'm appearing for. petition. Matter is settled.
The affidavit of opposite party number
2, my lord.
2.
Informant.
Confirming that the disputes have been settled between the petitioner and him is taken on record. That view of the matter, GR case number 106 of 2014 and all proceedings consequent thereto pending the court of the JMFC
Organ.
are hereby quashed. The petition is disposed of.
That's the record by me. MK Das for.
All right.
Obliged, my lord.
Fast or matter item number 56.
May it please, my lord.
Yes, please.
In this case, the case was registered against the petitioner and 2 others again under section 147, 148, 341, 323, 307, read with 149 IPC. Here, the matter has been the trial had been split up with 2 of the accused persons and the present petitioner, as the present petitioner was framed as absconded. And in the rest of the accused persons have been acquitted, and I pray for the this matter has been for quashing of the proceedings.
So you can apply for discharge. If others have got acquitted, you should just apply for discharge. You get it in no time.
2 of them have been acquitted. Out
That's
of the
right.
5 people, 2 are.
Permitting the petitioner to raise all the pleas raised in the present petition at the appropriate stage in the trial court, the petition is disposed of. The interim order is vacated.
Fast or matter item number 66.
I please your lordship.
Yes.
This is a case where the petitioner is a lady doctor
was serving in the hospital, my lord. It's a government PSC Balangir, my lord. On the date of occurrence, a patient was brought to the hospital, my lord, on the grounds that she had a delivery case, my lord. She was admitted, and the doctor said that it will be a normal delivery, for which, my lord, cesarean was not applied. During normal delivery, my male child was also.
So is the opposite side served?
Pardon?
Opposite. Is there any informant, complainant?
Informant, my lord.
They not made a party here, sir.
No. Lordship may permit me, my lord. I will implement.
Cannot, not at this stage, sir. We permit you to raise all the pleas.
Your lordship may
Permitting the petitioner to raise all the pleas urged in the present petition.
1 minute, my lord. May I pray? 1 minute, my lord.
Yes, yes.
This is a case where cognizance has been taken under section 304. My informant has nothing to do. 304 doctor against a doctor. 304A we can understand, my lord. But 304, my lord, and the inquiry report, my lord, committee has already reported that there may be error of judgment. No question of a 304, my lord. So my humble submission, people, lordship, a doctor while operating a patient, if the patient is alive, my lord, the child, a dead child was born. Therefore, my lord, how a doctor can be held responsible for 304, my lord, a direct decision, my lord, on the point, my lord, that is AR 2017 Supreme Court, my lord, at page 2078, my lord, Penal Code section 304A, medical negligence. Accused surgeon allegedly causing death of the deceased patient due to rash and negligent act. Deceased admitted in hospital for treatment of hemophilia. Accused after checking the deceased called physician and left the deceased without waiting for the physician to arrive. Physician did not arrive and conditions of the deceased worsened, resulting in death. Accused leaving the patient after checking without waiting for the physician to arrive is neither a rash or negligent act. Accused not guilty. This is a mere of error of judgment. And in this case, you also will find that there was a departmental inquiry, and the departmental inquiry is also available in charge sheet. It is clearly stated from the statement of both the parties and recorded and available in the office, negligence of Dr. D.P. Mishra could not be established. I am the doctor, my lord, could not be established. However, there is a slight error of judgment. So under these circumstances, my lord, you also will send me to face a trial, my lord, under section 304A, my lord. I'm sorry, 304, not even A. And when it is clearly an error of judgment, my lord, how it is 304, my lord? And no sanction. I'm a government doctor. Even accepting that I'm a government doctor, whatever I have done, not in my private clinic, not in my nursing home, that was in the hospital. If I have discharged my duty in the capacity of a government doctor, and if I will be prosecuted, my lord, no sanction is necessary. So under these circumstances, my lord, your lordship, this is the only, my lord, where your lordship can quash, my lord, because no sanction cognizance cannot be, your lordship may kindly see. Cognizance cannot be taken, my lord. That is.
Is he still in government?
No, retired, my lord.
He's retired now. So now let them proceed, sir.
I'll obtain instructions. I was looking to his age.
No, he must have retired, sir. He must have retired.
So your lordship, my lord.
It's okay, sir. Now this sanction issue will not arise. No longer government servant.
But by that time, cognizance cannot be taken. Which was cognizance was taken on 2014. By that time, as a government servant, and cognizance, my lord, no court shall take cognizance. That is the language of my lord. No court shall take cognizance if it is.
What do you say? When cognizance was taken, he was still a government servant.
Yes.
He was a government servant.
Yes.
So then cognizance could not have been taken. You say it is pointed out by Mr. Nayak, senior counsel appearing for the petitioner, that at the time when order taking cognizance was passed by the learned SDJM, Balangir,
yes, ma'am.
in GR case number 463 of 2018, under section 304 IPC, the petitioner was still a government servant, and such order could not have been passed without previous sanction of the government. Paragraph. On this short point, there is no issue there's no dispute raised by the counsel of the state. That view of the matter, while setting aside the impugned order dated 15 January 2014 of the SDJM Balangir, taking cognizance of the offence against the petitioner in the manner indicated, the matter is directed to revive before the SDJM Balangir to be proceeded with in accordance with law.
Your lordship, ma'am.
Matter will be listed before the SDJM Balangir on 12 September. Copy of this order be sent forthwith to the said court.
My lord, where your lordship may direct me, my lord, to raise that point, my lord, and he will decide in accordance with law.
Yeah. All other issues can be raised with the petitioner in accordance with law before the said court and will be decided by that court. Right.
Without being prejudiced by your lordship's order.
Without prejudice to any observation of this court. All right.
I'm obliged.
Mata number 60 of 2016 challenging the order decree of divorce passed by the Learned Family Court, Cuttack, order dated 26th May 2011. While order dated 19th April 2021, the matter was taken up and fresh steps for issuance of limitation notice on the respondent husband and his correct address was directed within a period of 10 years, failing which the matter would have been dismissed without further reference to the bench. The counsel for the petitioner failed to communicate the same, due to which the steps could not be taken and the matter was dismissed without further reference to the bench.
No, but several opportunities were granted and they are still at the stage of limitation only.
And the limitation is more than 5 years.
That's right. I think it has to be, yes. What is the reason given in the application?
Lordship, the counsel, then counsel of the petitioner failed to communicate.
No,
this
not
order.
so many orders. No, there are several orders.
Several orders. Since
Yeah.
2017, you are not complying with the direction to issue notice for filing requisites. Since 2017.
Correct.
Lordship, may say the illegality of the decree of divorce, it is an ex parte order, and the issue of permanent alimony has also not been decided. Your Lordship, in the interest of justice, may.
No, but the delay is enormous.
Enormous delay. Both in before the Just Family Court and here.
Yes. Yes.
Both.
Your Lordship may consider that the decree of divorce came to the knowledge of the petitioner in the year 2016. Although the
No, because again the same problem. She just didn't follow up on what was happening in the family court. Everywhere is the same issue.
Everywhere.
You see, there was already a delay of almost 5 years in the petitioner appellant filing the appeal in this court against the judgment dated 26th March 2011 of the Family Court, Cuttack. On that application being Miss Case number 85 of 2016, notice had been issued by the court way back on 3rd March 2017. But since then, for a period of about 5 years, steps for issuance of such notice was not taken. Paragraph. Repeated adjournments were granted and opportunities granted to enable the applicant to take such steps. Even up to 5 years after the filing of the petition, in particular, Reference may be made to the orders dated 8th March 2021, 19th April 2021. Full stop. Despite these many opportunities, with no steps having been taken,
Lordship would kindly
the order dated 5th July 2022 came to
may be
pass.
permitted to speak a sentence.
Yes, yes.
I'm sorry, Lord, my Lord.
Yes, yes.
But at the outset, Lord, I beg excuse for the inconvenience caused to your Lordship, my Lord. Here is a case, a lady, Lord, deserted lady. Divorce has been decided ex parte without permanent alimony, without maintenance, my Lord. She is living without a penny, my Lord. Lord, at least I'll be requesting your Lordship, let the matter be taken up so that she can get some amount of survival amount. That's all. This appeal, in fact, on the default of the lawyer has been dismissed, my Lord. She could not take steps for taking notice. That's all, my Lord. Kindly consider
Not
it.
for that's all. Just look at the history of the matter.
Lord,
See, initial appeal is delayed by 5 years. And then for 5 years.
I can understand. Lord.
For 5 years, only notice of the delay is being issued.
Lord, I can understand. Lord,
Filing
I
process.
beg all excuse for that. But all that your Lordship is doing, Lord, this lady will survive, Lord. The maintenance amount she is not getting. Lord, your Lordship may kindly consider this poor condition of this woman, but I am in fact helping her. I am also helping her, my Lord.
No, but
only on the question of maintenance, if your Lordship call upon the husband and decide it, my Lord.
No, but does maintenance have to depend on the, suppose you have to file a section 125?
Lord, your Lordship sees, my Lord, this divorce has been granted. Permanent alimony should have been considered, my Lord, at the time of granting divorce.
No, all that is fine. But the only question is 5 years is the delay, and then another 5 years only to issue notice on the delay.
It's
repeated orders are passed. Repeated orders are passed. See, shouldn't a person follow up? Whatever.
All that depend on the lawyers. Lord, these ladies, they do not come to the court, my Lord. They depend on lawyers. I can appreciate if
I'm saying she approaches the lawyer 5 years later. See, clearly the lawyer has filed this appeal itself 5 years later. It's a 2011 decree of divorce. The appeal is filed on 20th May 2016. It's a delay of 5 years.
That is there. That is there.
After that, why would she not follow up?
Or may I pray, my Lord? I can understand your Lordship's mind, my Lord. Ajay, I understand, my Lord, this is Mahapatri is also of the same view. Lord, if your Lordship gives some amount of relaxation, I mean relief, that she can go for Lord, seeking maintenance against the husband. That liberty we granted.
It is the council who can, not the court.
Lord, as a means of respite, your Lordship.
You can advise her better.
I'll definitely advise with your liberty from your Lordship, my Lord. I'll definitely.
There's no liberty here.
Not liberty.
Writing one line will not prejudice anybody, my Lord. She will go to the court.
No.
Even the present application is delayed by 11 months. Full stop. In these circumstances, the court is not inclined to condone the delay in filing the restoration application. Consequently, both the application for condonation of delay as well as the restoration application are hereby dismissed. All right.
As your Lordship.
Good afternoon. Pranam.
For orders item number 1, CMFL 290 of 2021.
But in this case, on the date of listing, I was feeling ill, so I could not attend.
No, what's the main matter about? Tell us.
Main matter, super challenging the order of ombudsman. As at annexure 5, page 18. Page 18.
Right. What does it do?
My lord, here the learned ombudsman has passed the order basing on the order dated as per the GRF order dated 26/2006. There at the relevant time,
the GRF has ordered to submit the bill on the basis of the 160 meter unit. But meanwhile, after the 2006, a new meter has been installed, and correct meter, it is not disputed by the opposite party that meter is defective. Her contention is that meter is okay, and accordingly bills have been served. But the learned forum below, without considering the meter, to consider the meter.
Tell us which portion of the order.
My lord, your lordship, kindly have a glance. Para 7 of the.
Yes, read it.
Text 20.
Kindly read it.
From the facts on record, it is established that bills issued from May 2009 till 17/3/2012 are wrong bills, as the meter came defective as per the report of the MRT meter testing laboratory. Hence, error claimed up to the period is not correct. Further, new meter is installed on 17/3/2012. That is the important. But strangely enough, no bill has been issued as per the actual meter reading till 2013. But average bill 2,505 units per month has been issued. Hence, although meter is functioning okay, as per the report of junior engineer, Sesu dated so and so, the bills raised up to 10/1/2000 are definitely wrong. Hence, no reliance can be placed on these bills. However, it becomes difficult.
So why did you not issue an actual meter reading, but the average bill? Why was that issued despite a new meter?
Well, that is the mistake has been committed by the department.
Then
but
naturally, therefore, the ombudsman is asking, after replacing the old defective meter, the new meter, still giving only an average consumption.
But it has to be recorded as per the reading recorded on the actual meter reading.
But you yourself have not done it. You've given an average bill of 505 units.
Yes, but so far as 160 is totally innocuous. 160, how can 160 what the meter is functioning?
It's all right, sir. These are not matters we are going to interfere. You say, for the reason stated, the CMAPL is allowed, and the order dismissing the petition for default is recalled. Writ petition civil 11288 of 2013 is restored to file. And then in the main writ petition, you say the challenge in the present petition by the executive engineer.
By the ombudsman, by the GR ombudsman.
Yeah. Electrical of the central electricity supply utility of Orissa, bracket says so, is to an order of the order dated 6th March 2013 passed by the ombudsman -1 in consumer representation case number OM bracket I 79 of 2012. Full stop. By the impugned order, the ombudsman has directed the present petitioner to rework the electricity bill issued to the respondent, opposite party, for the period from April 2009 to December 2012, treating consumption as 160 units per month and 2 kW load. Paragraph. The operative portion of the impugned order of the ombudsman notes that in para 7 notes that although new meter was installed on 17 March 2012, open quotation, strangely enough, no bill has been issued as per actual meter reading till 10/1/2013, but average bill 505 units per month has been issued. Full stop, unquote. When a specific query was posed to learned counsel for the petitioner as to why an average reading was being applied despite the meter being a new one, there was no convincing answer except to say that this was perhaps a mistake on part of the department. Paragraph. In the circumstances, on the factual aspect, the court is unable to find the ombudsman having made any committed any error in requiring the petitioner to revise the bill by treating the consumption as 160 units per month on the basis of the earlier readings. Paragraph.
Sir, ombudsman against the order of the GRF, He
No.
appealed to the ombudsman and the ombudsman has confirmed the order of GRF.
Correct.
Sorry.
That
Sorry, madam.
160 units as calculated by the GRF is correct, his order is correct. But so confirmed, the order of the GRF has been confirmed.
Sorry, my lord. Sorry, my lord. It is not confirmed. It is arise out of CC number 160/2012. But your lordship perhaps might have.
No. This is her appeal. She has come in appeal against the order of the GRF.
GRF filed with
GRF has dismissed her complaint.
Yes. This GRF
Ombudsman reversed the order of the GRF.
Basing on the 2006 order. Basing on the which is under Annex 1. Basing on 2006 order. They not confirm but reverse the order of the GRF.
The order is at page 18.
Yes, sir.
18, if you see the cost title, it's Deepa Banerjee versus Executive Engineer.
Sir.
So Deepa Banerjee, first paragraph, this is an appeal against it's a petition against the order of the GRF. Where the complaint petition has been dismissed.
Yes.
On technical ground.
Sir, see, sir, page 18, sir, the paragraph 7, the initial portion at page 18. That the Kotak in order dated such and such, wherein it has been, paragraph 7, sir, to a second, next page, in the paragraph 7 of the.
In some other case, I think this is some other case they're referring to.
2006.
Because her case was 116 of 2012.
Yes. Yes.
So I think this is for precedent value, he's quoting some other case.
Yes. The important order has been passed basing on the other cases which are disposed in 2006. Taken. When the meter is okay and consumption is okay. So it could have done on the basis of the actual meter reading, which has already been installed.
No, that was a defective meter, sir. You yourself admit it's a defective meter for that period.
Now at the time of a cause of action, a new meter has been installed and it is.
Sir, how come for that period they said there is no reading, reliable reading for that earlier period when meter was defective?
So law is on the basis of 119.
What do you want, Justice Rautre? You want to?
No, sir. I said, I just.
No. So this was reversing the order of the GRF.
Yes.
Court therefore finds no merit in the present petition. It's dismissed as such.
Item number 2.
Item 2, my lord, here is a case where on the basis of the MRT inspection, the load of the petitioner's meter was recorded 54, and according to the OERC regulation, a demand was made for the electricity security money, but he disputed the same. And as per the settled position law, if the meter is defective or something else, so electrical inspector the correct one to determine the same, as has been reported by the apex court since long. But here the opposite party has approached the GRF and it has been reversing judgment. The ombudsman has passed the order that not to demand the charges. That is the only allegation. If he could have approached the electrical inspector regarding the correct meter or inspection, here is not a theft or something like that, or general grievance. So he cannot approach the GRF or ombudsman. It is the electrical inspector who is the competent authority to decide the dispute.
All right, so that's okay. You say the present petition by the executive engineer electrical CESU is against an order dated 27th February. First, you say CM appeal is allowed. The order is recalled and restored to file. In the main writ petition, you said the challenge by the executive engineer electrical CESU is to an order dated 27th February 2021 of the Ombudsman -1, allowing the petition filed by the opposite party and directing the present petitioner to treat the maximum demand of the opposite party's unit as 25 kW from April 2012 to March 2013 and accordingly revise the bill. Paragraph. The only plea raised by the present counsel to the petitioner is that instead of straightaway approaching the CESU itself for grievance regarding the correctness of the electricity bill. The opposite party first went before the GRF Khurda and thereafter before the Ombudsman. Paragraph, the above fora have been created only to resolve disputes between consumers and the distribution companies. And in this instance, that is precisely what the opposite party has done. Full stop. The findings of the Ombudsman turned purely on facts, and an extremely detailed order has been passed discussing the entire facts threadbare. In the circumstances, the court is not inclined to interfere with the impugn of the Ombudsman. The petition is accordingly dismissed.
Item number 3.
Three, let it call some other day because
No. Let's see what it is.
I have not gone through the.
We'll go through it, sir. Don't worry. We can't sit every day for this. But these are not very complicated matters. Same thing again. Ombudsman again.
Let it be.
9 September. This is 4th August 2011 order. Let's see the order. 1 minute. This is against East Coast Railway itself. You don't spare even the railways.
Yes, ma'am. Let it be. I will solve the copy upon the CGC. So let it call some other.
No. Sorry.
I have not gone through the.
Not problem, sir. Even in a restoration matter, you don't go through means whose problem? It's your problem, not ours. You're as it is coming for restoration, but you're not ready with the matter.
Well, I have the impression that matter will be.
No. You are a seasoned lawyer, sir. You should know.
No, my lord. I am not seasoned.
Of course. It's all right. There's nothing in these matters, sir.
Well, let him call some other.
No, sorry, sir. We're not adjourning. We don't sit every other day. This is a special bench. We can't be assembling like this every other day.
Well, I have not.
That's all right, sir. I'll discuss this.
Sorry.
The reason stated, the CM appeal is allowed. That order is recalled and main writ petition is restored to file. The main writ petition says this is the petition directed against an order dated 16th August 2011, passed by the Ombudsman in.
Let him call some other. Sorry,
please, sir, please.
No, I will be misunderstood.
Commission case number 48 of 2011.
Well, I will be misunderstood.
It's all right, sir. We'll record all your submissions in great detail. Not to worry. Nobody will misunderstand you. The above petition came to be filed by the opposite party, East Coast Railway (ECR). Which filed a complaint before the GRF aggrieved by the testing of the metering of equipments. Full stop. It was alleged by the ECR that the metering installation was defective, and consequently the energy bills of the Kaipada Road Railway Traction Substation for the month of October 2010 was defective. Full stop. It is prayed that the bill must be revised, taking the average of the previous 6 months, that is from April to September 2010. Paragraph. The GRF concluded that the while the meter should be tested, while the apex meter installed at the Khurda grid substation should be tested, it was not correct for ECR to pay the energy bill for October 2010 by taking the average of the previous 6 months energy bills. Full stop. Agreed by the above order dated 21st December 2010 of the GRF. ECR went before the Ombudsman number 1, Bhubaneswar, with the aforementioned commission case. Full stop. As regards the order of the GRF requiring the present petitioner to take steps to complete the testing of the new meter, the order of the GRF was not interfered with by the Ombudsman. Full stop. As regards the issue concerning the revision of the bill, the Ombudsman observed that for the period the meter remained defective, the billing would be on the basis of the average meter reading, consecutive 3 billing periods, preceding the billing period in which the defect or loss was noticed. Paragraph. Having heard learned counsel the petitioner and having perused the impugned orders of the GRF as well as the Ombudsman, the court is of the view that no legal error has been committed by the Ombudsman. In coming to the above conclusion as regards the only contentious issue, namely revision of the bill. But stop, if admittedly the meter was defective and called for replacement, its replacement with the new meter, then obviously the billing had to be on the basis of the average for the preceding 3 months. The court is unable to therefore find any grounds to interfere with the impugned order of the Ombudsman. The petition is dismissed. All right. Right, sir. Okay. Thank you.
May I please?
For orders item number 1.
Miller. The persons to your lordship's direction.
Ah.
13/4/2022. The lordship had given direction to the managing director, the OHPC, to take a region to hear the representation as well as to take a decision by 1st August 2022. Now the managing director is out of India, Milord. He has gone on personal leave to USA.
All right, one more month's time. You are for the other side. Both of you are from the same party.
No, Millard, I am for the management.
Sorry.
OHPC.
All right. This is an application for OHPC seeking extension of 1 month time to implement the order passed by this court on 13th April 2022. For the reasons stated therein, the application is allowed. The time for implementing the order is extended by 1 month from today.
1 month, Millard.
All right. The application is allowed.
Okay.